All righty. So before Nicholas starts his presentation, I just want to read a little bit about Nicholas from his bio. So Nicholas was formerly a landlord over 20 years in Oregon and Utah and relocated to Olympia, Washington in July of 2018 to join the Housing Assistance Unit at the Department of Commerce for the state of Washington as the Landlord Mitigation Administrator, overseeing the program launch of the Landlord Mitigation Program and successful implementation of the subsequent programs. Nicholas brings a rich history of experience working with property owners, tenants, subsidy providers, tenant advocacy groups, and assets property management companies, and is considered Commerce landlord liaison. And take it away.
Well, thank you very much. Hello, everybody. My name is Nick Yuva. Nicholas is a formality because we have too many Nicks in the office. So I go by Nick typically. So if you call me, don't be afraid to call me Nick. But I do run the Landlord Mitigation Program. I've been here since 2018, which is when the program officially launched. And as noted, I do have some experience as the landlord. Department of Commerce offers several portfolios of business, but the largest bulk of that falls into housing and homelessness. That's where the Landlord Mitigation Program is centered. There is some talk that the state of Washington, and this is gone beyond conjecture to actual planning at this point, eventually will separate and we will have a Department of Housing in the future. As how soon that happens, we aren't sure, but we're such a large bulk of the business and commerce, we really need our own department. So that may you'll see that happen in the future. But in the meantime, commerce has been a fantastic place to offer this book of business. A little bit about me. I was a landlord, as I stated previously, for over 20 years. I worked in Oregon and Utah, worked for several property management companies starting in 1997, working my way up to getting my license, my accreditation, starting my own business, and eventually coming up to commerce, hanging up the hat of property management and bringing that experience to commerce to run this fantastic program for you. I'll tell you, if we'd had a mitigation program when I was a landlord, I would have been living very large. This is a fantastic and robust program that is just not commonly known throughout the nation. Other states and counties and municipalities are starting to pick up on it and design their own based on this program. So I'm excited to share it with you. Some of you may be aware of this program. In fact, a lot of you probably are aware of it, may have even made claims, received funding, or are waiting on funding. Good news, we've got $5 million coming in right now to pay some of the waitlisted claims. That'll actually take care of almost everything in our waitlist queue for all programs. So everyone that's sitting there that's been waiting on claims since earlier this year should start to see payments come out pretty soon once those funds actually hit our account. But one thing to keep in mind is that acceptance of the funds in the Landlord Mitigation Program prohibit the landlord from pursuing legal or collection action against tenants for damages and for unpaid rents from March of 2020 through December 2021. That hasn't been removed or stipulated in the RCW to have an expiration date. So if you have a rent that still owes during the eviction moratorium period, it's important to keep in mind that when you're submitting a claim to this program, you are not able to pursue those funds. And damages, you really want to put everything you can in this program. And I'll talk about the limits and what that means as we get to each program. The Landlord Mitigation Program started out as a very simple damage relief program. It was meant to be what's called a stigma buster. It was tailored to be a sister program to the anti-income discrimination law, which prohibits landlords from preventing access to their rental units to folks that are receiving rental assistance. It has grown into a much larger program. We've had a couple of programs that have come and gone, but the ones that have persisted are the Landlord Damage Relief Program, which is the original program, the Tenancy Preservation Program, which is temporarily closed, but I'll still go over the details of that as we plan to reopen that, and the Survivor Relief Program, which is the newest of all the sub-programs of the Mitigation Fund. Funding sources come from initially document recording fees, which equals about $4 to $4.2 million a year on average. And then we get legislative appropriations, and we receive those every year because $4.2 million doesn't cover the need in the program. It hasn't since the beginning, but the Senate Housing and Affordability Committee has been a very strong advocate and been providing appropriations annually to make up that unmet need. For this last year, or for 2023, we received $27 million as an example to help assist with the waitlisted landlord COVID relief claims, a program that's now closed. And this year we received 13 million, 8 million's already been spent, that 5 million's coming in. That will take care of the remainder of the wait list, with the exception of about 500,000, which we'll make up in a couple of months. So the damage relief program, again, this is the initial program. This has been the persistent one since the beginning. There is no sunset clause on this program, and we do receive regular funding from document recording fees and appropriations. But there are two types of claims landlords can file in this. So if you're renting to a tenant that receives rental assistance, the landlord can receive up to $1,000 and up to 14 days of unpaid rent when that rental unit fails the initial HQS inspection. The landlord takes the time to make those repairs and then moves that tenant in after passing a subsequent inspection. So you do have to fail that initial inspection, make the repairs, and then pass an inspection and move that tenant in to qualify. This does not affect the $5,000 claim that can be done later on. This is separate. So if you take the time to make the repairs and move the tenant in, you can get essentially up to $1,000 back from us. And we'll cover up to 14 days of unpaid rents for that period of time it took you between inspections to get that unit ready for the tenant. And then you can jump into the landlord mitigation fund of $5,000. So this is basically a secondary security deposit for tenants that receive rental assistance. It's not available to tenants that don't receive rental assistance. So when you're doing your screening and you have folks that are receiving assistance, this is a guaranteed extra security deposit for you of up to $5,000. You can make multiple claims throughout the tenancy for damages. So for instance, a tenant flushes a GI Joe or another toy down the toilet and clogs it up, and they can't get it out, and you got to replace that whole toilet, and it's about a $600-700 repair. You could submit that claim to us for reimbursement. You can submit as many claims as needed until you reach that $5,000 limit per tenant household. So you can do 10 $500 claims or one $5,000 claim. You can do it anytime during the tenancy or up to 1 year after the tenant vacates. So if you have a tenant that has damages throughout and you do make some claims, I recommend you hold on to about half for that move out. Right now, we're seeing averages of about $3,000 to $3,400 as move out charges in our claims. Now, some are much higher, but some are much lower too. But if you maintain at least $2,500 in there, you've got a good cushion at the time of move out to handle a lot of those repairs or additional charges. And when the tenant moves out, you can even include unpaid rents, utilities, and other charges that may come up during the move out process. But we don't cover lease break charges or rent responsibility. So anything that's masked as a lease break charge or rent for non-notice fee or something like that, it's not going to be covered by this program. But rent up to the very last day of tenancy will be covered. And again, all those damages and other charges can be thrown in. The landlord receives payment directly from the Department of Commerce. This doesn't go through the tenant or any other agency. It goes directly to the landlord because the landlord's the one submitting the claim. And I'm going to talk about the new portal. It's actually a pretty exciting tool that we have launched this year. But it's very, very simple for landlords to go through. It takes about 10 or 15 minutes, so long as you have all the documents scanned. And right now we're saying payments are currently received within 5 to 6 months from approval. That can vary. Like for instance, right now I'm telling folks some of the claims are waiting up to 9 months, but we're getting this $5 million appropriation into our accounts. So that's actually going to take a great deal less time. we're going to get everything caught up pretty much until up to September with this $5 million infusion. So again, this is it does take some time at times to get the funding. It is guaranteed once your claim is approved. There's no chance that funding will be revoked at this point. There's no legislation that's concerning to us that's on the horizon. The Tenancy Preservation Program was the second sub-program to launch under the Mitigation Fund. This program was designed to help prevent evictions. So when a landlord and tenant are in court for eviction for non-payment of rent, a court would find the tenant to be low income, limited resourced, or under financial hardship. And with that comes what's called an order of eligibility, that it'll state that the court has found them to meet these criteria, and the tenant is awarded a zero interest loan from the Department of Commerce. Commerce does not have a collection agency. We're not going to go chasing down the tenant, but if they don't repay this, they're not going to have access to this program in the future. So ultimately, we've seen claims come in as high as $40,000 to $60,000 in some cases during at the end of the eviction moratoriums. Unfortunately, these high volume claims did maximize the potential spending on the program. So we did have to temporarily close this until we have enough funding that can support it. We do have a request in the Office of Financial Management to offer enough funding to provide us that ability to reopen the program. It is a fantastic tool. And outside of eviction moratoriums and pandemics, we saw average claims at around about $6,000 to $8,000, which was much more sustainable in the program. We expect that we're pretty much back there based on the claims that we're seeing in the other programs. We're seeing a few stragglers come in with those really high balances, but for the most part, we're seeing claims come in with $3,000 to $6,000 balances. Again, there's no collection effort here whatsoever. And again, the landlord receives this payment directly from the Department of Commerce. So it does have to be ordered in court. The landlord does submit the claim, and the landlord receives the payment directly. The Survivor Relief Program is the newest of the program. It's not brand new. It's been around for about a year, and it's received only a few claims. And honestly, it's because of the what it offers that makes it difficult to qualify for. But this is one where survivors of domestic violence, sexual unlawful harassment, and sexual assault or unlawful harassment or stalking can vacate with no notice. The landlord is required to refund the entire security deposit, and in doing so, they are automatically qualified for up to $5,000 in the Department of Commerce's program. Now, there's no subsidy required for this program. So if you have a tenant that falls into these qualifying factors, you need to work with them to get them out quickly, so they can find safe housing, provide them with their security deposit, and then submit your claim. The program is not subject to public record disclosure. We want to make sure that all the identities are protected in this claim program. And the one piece that does create a little difficulty is that a lot of times the tenant may not make the landlord aware of this situation, or if they do, they flee immediately. And you do need some documentation from that tenant to qualify for that. We need qualifying documentation, which can be a police report, a copy of a restraining order, notarized self-affidavit from the tenant, or even a letter or notice from a caseworker identifying that tenant qualifies for this program. We try to make it as easy as possible, but we do require third-party qualification for this. And as an example, the last month we had several claims come in that we had to send over to the AG's office because they are blatantly fraudulent, and this has caused a bit of a concern for us. So we absolutely need that third-party documentation, and in this program we may follow up on that documentation. But again, this program is not subject to public record disclosure. Now, the new claim portal, if anyone's filed a claim prior to March of this year, They may have been familiar with our old system, which was the Smartsheet system. It was a good system. It was a simple application. You attach the scanned documents. The new portal is not too terribly different, except for the tools that it does offer. It gives you the ability to see claims that were submitted since March of this year, and all future claims. And we have an update coming out that will provide access to all of your historic claims, their statuses, and it'll even tell you the payment dates, if they've already been paid. You also have the ability to go do all the work directly in the portal, so it's not over email anymore. So you go into the portal, you have a claim that needs documentation, you just open the claim back up, add the documentation, and click resubmit. If you get an adjusted claim response and you want to accept or reject the adjusted amount, you can go right into the portal and accept or reject. There's no risk of an email getting lost or some communication not happening. It's all available to the claimant in the portal. And let's say you forget your statewide vendor tool. We even have a search tool built into the portal so that you can go in there. You have a new staff member, they don't know the statewide vendor number. They can use some basic criteria to find it and immediately begin their application process. And all the verification is in real time. This was a hurdle that we ran into with payments, especially payments to staff for a long time, like the Landlord COVID Relief Program, where statewide vendor numbers, which allow us to issue payments to each of the claimants, they would go invalid or get purged for non-use after 12 or 18 months. And that created a real hassle because it would get all the way to the point of where we're issuing a payment, but we can't issue the payment because the statewide vendor number went invalid. This checks that number constantly. So at the time of application, it's going to verify that it's a good number. It's also going to check it when I'm reviewing it. And then when we kick it over to accounting, when they pull it up to batch, it'll check it again. And then finally, it'll check it right before the check goes out. And if at any point it goes invalid, it'll kick out an email to the claimant saying your number's invalid. Please update this and provide us with your new number. And then I can go in at any time. You just notify me of the new number and I'll go in and fix that for you. And we'll get that payment issued on the next batch that it's available for. And then, of course, the best feature for you as the applicant is the ability to save and complete forms at a later time and date. Previously, the Smartsheet system, you had to complete it all and finish it all in one sitting. Right now, and the new portal, you can go in, you can start a claim, you can stop it at any point and save it. And you can come back to that, finish it if you're missing documents and you need to go to the office to get them or go to a different property to get them. You can do that and come back and you don't have to redo your entire claim. So everything it's a truly convenient system for the landlords, as well as us. We enjoy it quite a bit. And that is through Secure Access Washington. So you will have to log in or get a Secure Access Washington account. If you've gotten a statewide vendor number account in the past, you knew it took about 3 to 5 days to get that. And I'll talk about that more on the next slide. Secure Access Washington is almost instantaneous. Once you apply for it, it's going to kick out an email to you that you verify. And once you verify it, you can go in and log in and you're there. There's a couple of steps. We've got instructions on our website, which I'll share with you in a little bit, but it's also right down the bottom of the slide on the right side. The instructions are very simple, straightforward. It's got pictures and arrows, walk you right through the entire process of setting up your Secure Access Washington account, locating the portal within Secure Access Washington, and then you can access the program. And once you set it up so that once you access the portal, it'll remain on your login screen in Secure Access Washington, so you don't have to hunt it down every time. You just log in, it'll be there, click on it, it'll take you right into our portal. And statewide vendor number, I mentioned this a couple of times. For those that aren't aware, statewide vendor number is a number that's it's a unique number issued by the state of Washington. It's not a business ID number, it's not a tax ID number, it's not a TIN. It's a separate number that allows us to issue payments to each claimant. And this number is required. We can't issue payments without it. We can't even review claims or even accept applications without it. It takes about three to 5 days to get from the Office of Financial Management We have links again on our website. So I do recommend it, even if you don't have a claim right now, go ahead and get your statewide vendor number so you have it ready when you do have a claim. You will get a 1099 at the end of the year for the funds received from this program. This is to be treated as rental income, as it's really what it is. It's as if the tenant had paid you directly. So you'll get that 1099 issued at the end of the year, and the statewide vendor number is the information that's used to issue that 1099, as well as payments. You can set up direct deposit. I recommend that highly, especially if you have a business that has a DBA or a doing business as in the namesake, because the statewide vendor information will print both the registered name, the DBA, and then it will say DBA and then the DBA's name. And that has caused a few issues with the mailing system. So the USPS doesn't like DBAs on the letters, so they kick them back to us. So if you do have a DBA, especially, but even if you don't, I recommend setting it up for electronic fund transfer or EFTs, and you'll receive your payments about a week faster that way too if you do that. So highly recommended. We're at the frequently asked questions section, but the first question people like to ask is, can you appeal a decision? And ultimately, the answer is no. We are working on an appeal process, but it's going to be in very extreme cases. Typically, if your claim's been denied just because it's lacking documentation, charges that don't fall under the program or the program's guidelines, a lot of times it's because a documentation was missing or not signed. The most common one is the move-in condition report. This form is oftentimes not provided or else not signed. It is the highest reason of denial in the program. So if you're not using move-in condition reports, or you're not collecting them back from a tenant when you move them in, do that. It's absolutely required if you're holding a security deposit anyway, but you can't even access this program without it. So get that move-in condition report, have the tenant sign and date it, and you sign and date it at the time of move-in. So the law requires that the landlord and tenant execute the document, date the document at the commencement of tenancy. This is not going to be something that you should have them electronically sign. So if you're electronically signing the lease packet and one's included in it, we're not going to accept that. We want to know that the tenant had the opportunity to walk through the unit and note any damages. So you want to make sure that we have accepted electronically signed ones in rare instances. Typically, they're electronically signed at a date later than what was signed by the in the lease packet, and it's somehow filled out. To be honest with you, this form really shouldn't be electronically signed. It should be manually filled in and signed, and it should be filled in by the tenant, not the landlord. So I highly recommend you just do it right. We've got a sample form on our page if you don't have one. So go ahead and download that, use that all that you want to go ahead and make sure you're in compliance. But it must be done at that time of move-in. There is one other option. If we deny your claim or we adjust it to a point that you aren't satisfied, you could potentially go get a judgment against that tenant and then submit the judgment to us, and we would accept it up to the $5,000 limit. We don't encourage this quite simply because if it doesn't meet our standards, it's going to be really hard to prove in court. If you don't have that move-in condition report, that's an immediate defense for the tenant. So I recommend that you just look at the documents, make sure the documents are clean and right. We'll take care of you. We've satisfied a lot of clients over the years.